So when you have received a decision in family court that you are not completely happy with, there are a few things that you can do to challenge that decision. Some of those go back to the same district court judge, and some of them go up to an appellate court. So the first option that you have is the one that you have to do the quickest. It's called a motion to reconsider. When you file a motion to reconsider, it doesn't really have a legal standard. It's just saying, hey, judge, I think you should reconsider this decision that you made, but it gives you an opportunity to go in and add more evidence, to make arguments you didn't make, and to give the judge another chance. Additionally, if you're planning on appealing your decision up to an appellate court, it also gives you the opportunity to have those arguments and evidence put into the court record for the purpose of that appeal as well. The second option you have is a motion for a new trial. This has to be filed within 28 days of the decision, and it has a very specific standard that has to be met for it, unlike the motion to reconsider. The third option you have in front of the district court is to file a motion to set aside. This one has a 6-month time period, and it can be even longer than 6 months if there's been fraud in it. But the general standard for a motion to set aside is mistake, inadvertence, excusable neglect. Often it's for situations like if there was a default against you because you didn't know about the proceeding or you didn't realize how serious it was, and you want to go in and get this judgment that was entered without your participation set aside, things like that. And then the last option you have is to appeal up to the appellate court. And that's done by filing a notice of appeal. And that notice of appeal has to be filed within 30 days of the notice of entry of order that you're going to be appealing.